All right. Welcome, guys, gals, and everything in between. Welcome, Shawn.
Thanks for having me.
Yeah. So today we are going to do something we've done in the past, which is cover a hearing, but this is a little different, the hearing at least, right? So Trump recently has made a lot of noise talking about judicial overreach and these, quote, activist judges that are blocking executive orders and various attempts by the Trump administration to remove the incredibly high number of illegals that we have in this country. We've heard a lot about that recently on mainstream news, talking about, they arrested a judge. Oh my God. The same people that told us no one is above the law. And regardless of everything else, this particular judge that I'm talking about is on video camera as like
helping immigrant evade ICE.
Law enforcement. It's not cool, dude. That's literally against the law. So the other one, I don't know the story with that one.
Are you talking about the judge in New Mexico?
Yeah, I don't know the deal with that one.
Allegedly, he was harboring an illegal immigrant in one of his houses.
Oh, okay. All right, then. Well, that's not cool, man. Just
allegedly.
Yeah, allegedly. All what is it they said on cops? All suspects are innocent until proven guilty in a court of law. And that's true. Here in the United States, we are innocent until proven guilty. That said, this particular hearing is very interesting for me because I tend to agree with Trump insofar as I don't think some little district court judge should be able to stop the president of the United States.
There needs to be reform.
There does need to be some degree of reform. Now, one of the things that they're talking about that I know Speaker Johnson was saying was there's, I guess, an appetite for, at least among Republicans, for impeaching some of these judges. And according to him, he doesn't think it'll fly, not because they can't get it past the House, because they could, but it'll die in the Senate.
And we got to be careful when we start impeaching judges because it can come back because they've been for years wanting to get Thomas off the.
That's true. Yeah. When we start following through, apparently there have only been I think less than a dozen judges in the history of this country that have been impeached. I want to say 9. Was it 9? Yeah.
And the last one I watched the hearing or the trial in the Senate like 2 years ago. They got rid of, but he was convicted of, I can't remember what kind of crime, but some sort of crime.
Okay. So he was actually convicted of a crime.
That's why he was removed.
Yeah. And in that case, when you're convicted of a crime, I mean,
it doesn't happen
hard to be a judge.
It doesn't happen very often that anybody gets removed from office.
Right. Okay. So we're going to jump into this. This is in front of the House Judiciary Committee, right? And they're talking about this. Well, this is the other part of what Johnson was talking about. He said he doesn't think that the impeachment is going to proceed with these judges, but this law that they're working on should help to curb.
Yeah, they're trying to make it where they can't do a nationwide injunction, only like for their district or something.
Okay.
Which I don't know how that would work.
I don't know how that would work either. But let's get into this and see.
And this is Daryl Issa, who's the chair of the committee.
There we
go. Republican representative from California.
There's a Republican from California?
Oh, yeah. He's one of the good guys. I like Daryl Issa.
All right, here we go. Nope. Hold on. Let's try this again.
I'll recognize myself for an opening statement.
There we go.
We are here today because a major malfunction in the federal judiciary has been recognized by both Republicans and Democrats.
Yep.
Activist district court judges usurping themselves with their Article III power and imposing on the nation injunctions beyond the scope of what the United States Congress under statute has given federal judges. These rogue judge rulings are a new resistance to the Trump administration, and the only time in which judges in robes in this number have felt it necessary to participate in the political process rather than to participate in the Article III powers given to them both by the Constitution and by statute.
Now, one interesting thing that he just said was these district judges are exceeding the power granted to them by Congress. So this whole district court judge thing, was that part of the Constitution that you recall? The Supreme Court is.
I don't think the other case. No, I think the only one that was actually created by the Constitution was the Supreme Court.
Okay.
But throughout time, the court.
And of course, our local, the way that it works locally is also in our state constitution.
But that's different.
But it's different than the federal. Right. As far as a federal level, he just said both Congress and the Constitution. So I assume there's some degree. I don't know what it says in our Constitution about district judges.
Congress has created courts throughout the years, and the only one that was created by the Constitution was the Supreme Court.
Right. Okay. Interesting.
President Trump was elected to assert many policies, including the deportation of criminal aliens. He did so publicly and was elected by a majority of Americans and the vast majority of the Electoral College. But he also did so in stark contrast to executive orders of the previous administration. Time and time again, rogue judges have asserted, as though they were 5 of the 9 members of the Supreme Court, their authority when the president was doing nothing more than undoing a policy of his predecessor, one which they seem to have no problem with in the previous administration.
Yeah.
Let me be clear, it should never have come to this. It is within the Supreme Court's ability to rule appropriately that judges have exceeded their jurisdiction. Time and time again, the High Court has ruled on the substance of the ruling rather than on the inappropriate nature of an injunction overly broad and affecting hundreds, thousands, or millions of people beyond the plaintiffs before that court. Just last night, a judge halted the administration's plan to end temporary protective status for about 350,000 Venezuelans that Joe Biden welcomed into this country and gave temporary protective status to. Temporary seems not to be a word understood by the court. If President Biden could give protective status temporarily, how, in fact, could it not be the prerogative of the next president to undo that status?
That seems like a fairly straightforward, give and take there. If it's in his purview to create this, it's in his purview to remove this. Right?
Yeah.
It
wasn't created by Congress.
Right.
Where in that protective status was there an act of Congress or a recognition that temporary equals permanent?
Right.
This is but the latest outrage coming from lower, or at least I might say the lowest courts. I have said from the start that my colleagues on the other side of the aisle should support this legislation. After all, it was the Biden administration who opposed these universal injunctions and said they were illegitimate. In fact, legislation in the last Congress, authored by a Democrat, is substantially similar to the one that we offer today and would have the same effect. To quote the previous administration's Solicitor General, literally the woman who spoke on behalf of the administration before the court, she said, "The government must prevail in every suit to keep its policy in force, but plaintiffs can derail a federal program nationwide with just one lower court victory." End quote. Those words by Elizabeth Prolongar, President Biden's own Solicitor General, were from October 2024. In other words, after almost the entire 4 years of the Biden administration, they still believed and believed till the end that this was wrong. And yet, we will probably hear today no support on the other side of the aisle. In fact,
I believe it.
This is not new, but it is not old. For 180 years of our nation, there were no such injunctions. Only beginning in 1963 did district courts begin to, in relatively small amounts, believe that they could do these without multiple plaintiffs from multiple circuits.
So, never mind.
From 2001 to 2023, the number grew to 96. But an incredible 64 of those occurred during only 4 years, the 4 years of President Trump.
64,
Meaning
yeah.
that more than half of all injunctions in this millennium, this century, were against President Trump in his first 4 years. That used to seem like a lot, but during President Trump's first 9 weeks in office this year, he has already faced more nationwide injunctions than President Joe Biden did in his entire 4 years.
Yeah.
Imagine
The federal
that.
judiciary isn't interpreting the law. It is impeding the presidency. It is, in fact, not co-equal, but holding itself to be superior.
I mean, that's really what it comes down to.
The branches are supposed to be equal,
Right.
But with the judiciary is trying to make them more power than the legislators.
Yeah, and that's an interesting point, right? If the branches are supposed to be equal, okay, then can we pretend that a mid-level bureaucrat, right, in the West Wing somewhere has as much power as the Supreme Court? Of course not.
No.
That's a silly comparison, right? But that's what's happening.
Uh-huh.
These mid-level bureaucrats, district court judges, are saying, "Oh, we're issuing this injunction," and it's, supposed to somehow stop the policies of the duly elected president of the United States of America. That's ridiculous.
Yeah.
It's just beyond absurd. All right. Our next little clip is from Representative Johnson.
The dumbest member of Congress.
Is he?
Yes.
Oh, this guy. Yep.
You know who he is,
As
right?
soon as I saw him, yep. I wholeheartedly. This guy is brick. 2 bricks rubbed together stupid. I mean, good God.
Why?
Is this the same guy that talked about Guam flipping over? If you haven't heard this, and some of you maybe haven't, look up this guy, Guam tipping over.
And he said other things that are ridiculous.
Almost as stupid. He said, with all those troops, isn't Guam going to flip over?
Yes.
Bruh. And this guy somehow won his next election. Easily won his next election, which either somebody's cheating, people aren't paying attention, or both.
I think it's the second one.
I'm just saying.
Come on, Georgia, do better.
Right, do better, guys.
Of the many troubling actions the Trump administration has taken in its first 71 days, among the most damaging are his authoritarian, dictatorial, and unprecedented use of presidential power to instill fear, intimidate, exact revenge against, and punish those who dare to stand up to him and hold him accountable to the laws of our nation. A climate of fear and trepidation has descended upon the nation. The people of America are more afraid today for our democracy and for their personal safety than ever in our lifetimes.
I'm just going to say this. The vast, I'd go overwhelming majority of the people that I interact with across all parties are not afraid right now. They're actually quite hopeful. There may be certain people that are afraid, probably because they broke the law, but I'm just going out on a limb here. But the vast majority of people are not sitting there terrified because they haven't broken the law.
Uh-huh.
College
Bruh.
students have disappeared off the streets paramilitary style by plainclothes, mask-wearing individuals and held incognito for days before they are discovered thousands of miles away in some private for-profit ICE detention facility. Why? For exercising their free speech First Amendment rights.
I just want to make sure I understand. So Democrats are perfectly okay with for-profit prisons here in the United States, but not overseas. I just want to make sure I understand that. Just checking, because every Democrat I've talked to, I worked at Indiana State Prison. Some of the aspects of ISP are privatized, food service, etc. I have talked to Democrats about that. They don't really give a shit. So they're okay with privatized prison as long as it's here. But if it affects illegals, then we have a problem. Mm-hmm. These people make me ill, dude. They genuinely do.
Universities,
they're not serious.
Bastions of free thought have been punished for having the wrong ideology by having their federal funding revoked. And major law firms that dared to have brought cases against King Trump have been targeted with blatantly unconstitutional executive orders that, if allowed to stand, would shut those law firms down.
Okay.
Yeah, I didn't want to listen.
Yeah, that's more than enough of him. And I get why you put it there, and I get why
meet the ranking member.
That, and what is their big complaint, right? Their big complaint is it's Trump. That's their complaint, guys. That's their reason that this is a bad idea. You know, basically reining in judicial overreach because it's Trump. If it was anyone else, as he said, a Democrat's actually the one who wrote the previous piece of legislation, which is very similar to this. They were okay with it then, but not now. Okay, we're going to jump ahead to Roy. Is that Chip?
Yep.
Good old Chip Roy, 4139. We're close. A little too far. Close enough.
What she's going to be here to testify about today and her great service. So with that, I would like to take a slightly different angle as the chairman of the subcommittee on the Constitution than the direction that my friend from California took.
Okay.
Because I want to emphasize the judicial overreach we've witnessed over the last 2 months.
Yes.
And nationwide injunctions more broadly that are undermining the constitutional structure our founders so wisely envisioned. The nature of the executive branch was a primary point of contention at the Constitutional Convention. Some delegates favored a plural executive, thinking that this arrangement would better preserve liberty. But they were wrong, and our founders wisely resisted their calls. Instead, the Constitution lodges the executive power in a single president of the United States. Alexander Hamilton offered the classic defense of this arrangement in Federalist 70, emphasizing that a vigorous and energetic executive is necessary to defend our liberty from foreign threats. Hamilton rightly argued that unity in the executive was the essential ingredient in this formula. Only a single executive could act with the decision, activity, secrecy, and dispatch necessary to adequately carry out the office. And on a note, I have introduced legislation in the past, it's called the Article 1 Act, to try to cabin in the executive branch when it's not necessarily working directly with Congress. And I'm happy to work with my colleagues on the other side of the aisle on these concepts when we have these lingering emergencies. In many cases, these national emergencies that date back to the 1970s. There are times for the Congress and for the legislative branch to assert itself. But the president's authority is at its zenith when we're talking about his actions as commander-in-chief. Injunctions and temporary restraining orders halting presidential actions nationwide threaten the key feature of our constitutional architecture, undermining the core premise of unity in the executive branch, the unitary executive, as we refer to it. Even the most strident proponents of a plural executive at the Constitutional Convention advocated for an executive council of 3, maybe 5 members. Today, in practice, we are governed by an executive council of 678. The nationally elected president and 677 district court judges, each of whom retains a functional veto over executive actions through their power to issue nationwide injunctions. Scholars have long understood that a hostile judiciary or even a single hostile judge could abuse its power to issue nationwide injunctions to infringe upon the lawful authority of the President of the United States. Now, that's not a partisan point. I've got numerous examples of our colleagues on the other side of the aisle who have raised these concerns. The Biden administration's Solicitor General, Elizabeth Prelogar, told the Supreme Court as recently as 2024 that, quote, a court of equity may grant relief only to the parties before it. The district court violated that principle by issuing a nationwide injunction, ... In 2022, Solicitor General Prelogar asked the Supreme Court to address nationwide injunctions as permissible relief in the United States versus Texas, arguing that district courts normally, quote, should only provide relief for the benefit of the prevailing challenger. What happened there was our Democratic colleagues started realizing that when Republicans went to district courts to get injunctions against their president, that suddenly they didn't like it so much.
Yeah.
So they were raising concerns. Justice
right.
Elena Kagan spoke out against nationwide injunctions by a single district judge in 22, quote, the ability of a single judge to stop implementation of a policy across the country. She stated, in the Trump years, people used to go to the Northern District of California. And in the Biden years, they go to Texas.
Yeah.
Just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. Former United States Rep. Mondaire Jones introduced the Injunction Reform Act in 2022. I could go through the quotes that he offered, but I won't. I can offer those for the record without objection. In a letter to William Torrance dated June 11th, 1815, Thomas Jefferson explained who decides constitutional questions. Certainly, there's not a word in the Constitution which has given judges that power, authority to decide on the constitutionality of a law more than to the executive or legislative branches, meaning we all have an obligation and a role to do that. Questions of property, of character, and of crime being ascribed to the judges through a definite course of legal proceedings, laws involving such questions belong, of course, to them in the judiciary. And as they decide on them, ultimately and without appeal, they, of course, decide for themselves the constitutional validity of the law. In other words, our founders never intended the federal courts to have the ability to unilaterally decide constitutional questions, as these judges are unelected and were never given the power to legislate from the bench. Treating the courts as the final authority on public policy, grants them more power than even Madison's rejected Council of Revision proposal at the Constitutional Convention.
Nailed it. I mean, that really just sums it up. They were against it, then they're for it, then they're against it again when Trump's back. I mean, come on. Like,
it's all politics.
It's all politics. All right. The next one is Scannion. Is that how you say that?
Yeah.
Representative Scannion.
Democrat from Pennsylvania.
All right. And just guys, just so you, I don't know if you guys can see, down in the bottom here, apparently this entire hearing is over 5.5 hours long. So most of your workday, Shawn was kind enough to pick out the salient bits, the important parts, so that we wouldn't have to sit here for 5.5 hours, because that's too long.
That's a long time.
That's a long time. Okay. Scannion. Is that this guy?
Nope, that's ISA.
Oh, yeah, is it Isa? Isa?
It's ISA.
Isa. Okay.
ISSA.
We got roughly about 3 minutes ish of Representative Scannion. Here we go.
Democrat from Pennsylvania.
Thank you.
Democrat from PA.
Like the chairman of the subcommittee on the Constitution, as ranking member, I too would like to address the constitutional concerns raised by this hearing. Our Republican colleagues have called this hearing today for one reason, because this White House, this president, continues to lose over and over again in court, as people and groups from across the political spectrum challenge the barrage of unconstitutional and illegal executive actions taken by this White House.
I'd just like to point out for the record that that's not even remotely true. The vast majority of the cases that are attempted to be halted, Trump ends up winning. Right?
He's lost a couple.
Of course, he has, but
I think he's won quite a bit.
He's won quite a few. Anyway.
In just the first few weeks of this term, because it doesn't matter if the judges were appointed by Bush or Biden or Obama or Reagan or by Trump himself. When the president attempts illegal or unconstitutional actions, United States judges, guided by the letter of the law, must rule against him. It's a confirmation of the total subservience of today's Republican Party to this president that their response to multiple judicial rulings of executive overreach is a hearing entitled Judicial Overreach and Constitutional Limits on Federal Courts, when we should be holding a hearing on presidential power grabs and constitutional limits on executive power. This is Civics 101. The Constitution provides in Article 1 that Congress writes the laws. In Article 2, the president administers the laws. And in Article 3, the courts interpret the laws. Our Republican colleagues are concerned
That's
about
actually
the
not what it says.
unprecedented
No.
number of successful lawsuits.
I actually just read it while
Yeah.
yeah, it doesn't say that. We'll if I remember, we'll cover it at the end because I think it is important and salient here, but let's move on.
Challenging this president's executive overreach. But it's not the actions of the courts in interpreting our Constitution and laws that are unprecedented. It's the scope and breadth of this president's executive orders that are unprecedented.
Right, of course, it's all Trump's
It's
fault.
this president's attempt to go it alone, to usurp the power of Congress and we the people, to rewrite the laws of this country and the Constitution, and to reserve unto himself, rather than the judiciary, the right to interpret the laws and our Constitution. The sheer volume of unconstitutional and illegal actions taken by this president in just the first few weeks of his term has led some to wonder if the president fundamentally misunderstands the nature and terms of his Article 2 powers. Specifically, when Article 2, Section 3 says that the president shall take care to faithfully execute the laws passed by Congress, does this president think that the word execute means that he's supposed to kill laws rather than carry them out?
Ridiculous.
Unfortunately, the underlying rationale
You're
for
not
much of this
funny.
action is
She's
a radical
not
theory
nearly
set
as
forth in
clever as
Project
she thinks she is.
2025, and the
Oh, here we go.
rationale
I
for
knew it
much
was
of this
coming.
action
There
is
we
a
go.
radical theory set forth in Project 2025
They
and
cannot
elsewhere.
leave that alone.
It's one that
Nope.
would vest federal power in a unitary executive, sidelining two of the three co-equal branches of our government, Congress and the judiciary. We're here because
Just in case you know, the Democrat viewers that she's reaching out to with these obvious sound bites can't count, which, you know, I get it.
Republicans who control the House and Senate have, thus far, chosen to abandon their constitutional duty to constrain an out-of-control executive branch. If they don't see anything wrong with it, their constituents do.
You're wrong. You're
It's a
absolutely
double
wrong.
standard.
Trump's approval ratings are higher than they've ever been. Last I checked.
They're a little.
Did they fall a little?
They're kind of shaky.
Okay. Well, the last that I checked,
They seem to be falling according to the polls because of the tariffs, but
we'll see. And that maybe that's possible, right? People tend to get mad when you take away their cheap Chinese crap.
And
But
the stock market, I think that has something to do with it too.
it probably does. All right, so we're going to skip ahead here to 1 hour, 10 minutes, 44 seconds. And we are at intro of witnesses. That's what I mean, guys. This is a long ass hearing. Where are we at here?
Not
Almost there. Not quite. It's hard to see that like white on the white.
Yeah, this is a long hearing.
Okay. 110:44, and we're going to go to 113:27.
Objection, so ordered.
Here we go.
Without objection, all other opening statements will be included in the record. I'd now like to introduce our distinguished panel, beginning with the Honorable Newt Gingrich. Mr. Gingrich is the former colleague here in the House and served from 1979 to 1999, including 4 years as the Speaker of the House. Speaker Gingrich was instrumental in formulating Contract with America and returning Republicans to a House majority after 40 years of Democrat control. Since leaving the Congress, he has remained incredibly active, and in fact, in both policy, politics, and government, he has led, having authored several dozen books and teaching military officers and other national security professionals at the National Defense University. Welcome, Mr. Speaker. Mr. Paul Larkin. Mr. Larkin is the John Barbara and Victoria Rumpel Senior Legal Research Fellow at the Edwin Meese III Center for Legal and Judicial Studies at Heritage Foundation.
That was a mouthful.
Yeah.
He was going word by word. You could tell, because that's probably a massive freaking clump of text he's staring at. Think about all the big, long ass words in there, man.
Yeah.
Unfamiliar words, not just long words, but like, what?
Before joining Heritage, Mr. Larkin served in various positions in the Department of Justice and at the EPA and as a Senate staff. He has spent a number of years in private practice and is most prepared for today's hearing. Welcome. Ms. Cindy Romero. Ms. Romero is a resident of Aurora, Colorado, who saw firsthand the effects of soft on crime and open border immigration policy. She was a resident of an apartment complex targeted by Tren de Agua and eventually was forced to move after her neighbors were reportedly victimized and her car was struck by gunfire.
Bruh.
Lastly, Professor Kate Shaw. Ms. Shaw is a professor of law at the University of Pennsylvania, Carey Law School. Professor Shaw focuses on executive power and the Supreme Court, along with other issues. I want to welcome all of our witnesses and ask that you please rise to take the pledge to be sworn in. Right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and correct to the best of your knowledge, information, and belief? So help you God. Please be seated. Let the record reflect that all witnesses answered in the affirmative.
Man, oh man, I can't even imagine living in the type of scenario that woman from Aurora went through. Like, in America, dude, like, and that's part of the problem with these liberal strongholds. You no longer have the right or ability to defend yourself.
Nope.
And you pull some shit like that in Indiana or Texas or another red state, bruh, good luck.
End well.
Yeah, it's not going to end well.
For you.
All right. We're for the bad guys.
Yeah,
it
that's
won't
what I
end
meant.
well. Yeah, it'll end real well for the residents because tell you what, man, I know certain sheriffs that are be like, yep, looks good here. Everything looks like self-defense. Let's get these bodies out of here. I mean, you know, speaking
that's why
of,
we don't have those problems.
yeah, that's
All right,
exactly right. I was going to say, what's that sheriff from Texas? Grady Judd.
Yeah.
You know who I'm talking about is it Polk County? It's one of those counties. Anyway,
I know what you're talking about.
Yeah, he's very forward about that kind of stuff. All right, so Larkin is our first one up.
Might be just go fast forward like 5 seconds, probably the best.
It's right
It's
up
only
here.
a minute.
All right, 114:33 to 119:11. So we got about 5 minutes. Here we go.
The legislative power is granted to Congress. And what is the primary product of that legislative power? It is what the Constitution defines as a law.
Mm-hmm.
The term law also shows up in Article 3, but it shows up in Article 3 under the phrase arising under the Constitution, the laws, or treaties. It is not the courts that are responsible for creating the law. It's the courts who are responsible for interpreting it as it applies. But they can only do so in the context of a case or controversy. Two structural limitations on what the courts can do. In other words, in order for the courts to be able to say what the law is, they have to get on the playing field. And in order to do that, you have to have a case or controversy. Now, why does that matter? Well, the Constitution does speak to this. As I've said, Only the Congress can create a law. Anytime a court enters a judgment that is tantamount to being a law, the judge has gone too far. And in the case of nationwide injunctions, a judgment in favor of non-parties goes too far.
Agreed.
You also have no statute in the Judicial Code, no provision in the Constitution, and no settled history at common law that allows a judge to enter these sorts of orders. That's important because everything has to fit into one of those three. Why? The Supreme Court has interpreted Article 3 in light of how it was understood in 1789. And so those are the three primary bases that you have to look to: the text of the Constitution, statutes, and English common law history. In fact, there are two Supreme Court cases that directly undermine the legitimacy of nationwide injunctions outside of certified class actions. One is Williams versus Zabarez. In that case, the court said there is no case or controversy between two parties that are in a case over an issue that has not been put into dispute by one or the other of them. It logically follows that there is no issue in dispute between someone who is a party and someone who is a stranger to the entire litigation.
Right.
Similarly, at the back end of the process is the case of United States versus Mendoza, where the Supreme Court held that the federal government is not subject to the win or go home rule that you see in the NCAA postseason tournament. The government isn't stuck with whatever loss it has the first time it litigates a case to a final judgment and loses. The doctrines in the law of issue preclusion or collateral estoppel, the new and old terms, do not apply to the federal government. Why? The Supreme Court, in the unanimous decision in Mendoza, said they do not. Why? Because there are a variety of good policy reasons why it shouldn't. With that, then let me turn to the policy reasons that show this practice is unwise. There are several, okay? First, mandatory injunctions prevent the percolation of issues in the lower court that the U.S. Supreme Court in Mendoza said is necessary for that court to be able best to resolve whatever legal dispute there is. It allows the court to be sure that all of the issues, all of the sub-issues, all of the arguments pro and con, all of the benefits and costs of whatever rule are fully aired. Secondly, it encourages judge shopping.
Yeah.
All you have to do is find one favorable judge, and you can stop an entire administration in its tracks.
Yeah.
And as you know, it has happened to every administration over the course of this 21st century.
Yeah.
From the George W. Bush administration to the present. Each party has been subject to this practice. Third, it can result in conflicting nationwide judgments. You can wind up with injunctions going one way and the other way because a court in Maine and a court in Alaska can come out the opposite way in a case. Finally, they are going to weaken the doctrine of stare decisis, because as the Supreme Court comes to realize, if it has to decide issues at a preliminary stage of the case without the guidance of the lower courts, they're going to have to overrule some of their decisions. Let me end where I began. This practice is mistaken as a matter of law and unwise as a matter of policy. Thank you.
I agree with him.
Yeah.
I mean,
it really does need to be reformed.
Yeah. And look, we've seen it the other way as well, where we were like, dude, this is blatantly illegal. Things that Biden has pulled that we thought this is blatantly illegal. And the judge will issue an injunction, and then next thing you know, it'll make its way up and it'll either be upheld or reversed. But did that really need to happen that way? I don't think so. Like he said, it encourages judge shopping. You just pick the right judge and you're going to get what you want. Shouldn't work that way. Okay. We go right in, actually a couple seconds. And we're going to go to Newt Gingrich, and we're going to play just a couple of minutes from him. Here we go. He can be kind of long-winded, and he says a lot of the same stuff he's said in the past. So here we go.
Thank you. Speaker Gingrich.
Thank you, Chairman Issa and Roy, Ranking Members Johnson and Scanlon, and all the members of the subcommittees for allowing me to testify. There is clearly a potential constitutional crisis involving the judicial branch's effort to fully override the legislative and executive branches. 15 district judges effectively seized control of various executive branch duties in the first 6 weeks of the current presidency through nationwide injunctions. This is potentially a judicial coup d'etat. It clearly violates the Constitution and more than 200 years of American history. To set the stage for this hearing, let me mention 12 former federal judges appointed by President John Adams: Richard Bassett, Egbert Benson, Benjamin Bourne, William Griffith, Samuel Hitchcock, Philip Barton Kay, Jeremiah Smith, George Keith Taylor, Oliver Wilcott Jr., Williams McClung, Charles McGill, and Williams Tillman. President Adams appointed these federal judges on his way out of office to hamstring the incoming President Thomas Jefferson's agenda. President Jefferson concluded that impeaching the judges would take too much time. He and the Congress simply abolished the courts in which they served via the Judiciary Act of 1802. This is a constitutional balance of power. The legislative and executive branches can reshape the judiciary branch. It is a useful reminder in considering the current situation. Unelected lower court judges have been steadily grabbing power for years. It was such an obvious threat that in 2012, Vince Haley and I wrote, "Bringing the Court Back Under the Constitution." It is an historic study which I am submitting for the record. According to Harvard Law Review, there were 96 nationwide injunctions ordered by district courts from 2001 to 2023. 2/3 of them, 64, were issued during President's time in office. Furthermore, 92% of the injunctions against President Trump were issued by judges appointed by Democratic presidents. Since January 20th, 2025, lower courts have imposed 15 nationwide injunctions against the current Trump administration. This is compared to 6 during George W. Bush's 8 years, 12 during Barack Obama's 8 years, and 14 during Joe Biden's 4-year term. The notion that unelected lawyers can micromanage the executive branch and override a commander-in-chief who received 77.3 million votes should trouble every American.
Yeah.
Absolutely. Absolutely. Imagine if, just for a moment, right? Like he said, there have been way more injunctions against Trump than any other president. And look at the numbers from the last election. Democrats are going to argue any way they possibly can that it wasn't a majority because it wasn't 51% and it wasn't this and it wasn't that. It doesn't fucking matter. He's elected legally, correctly, whatever, by an overwhelming number of your neighbors, guys. Period.
He had a mandate.
Period. Yeah. I wholeheartedly agree. All right, we're going to jump ahead and we're going to hear from Cindy Romero. Is that the one from Colorado?
I believe, yes, it is. She tells her story.
A little too far. All right, we're at 124.25. Close enough. And we're going to go to 131.12 with Miss Romero.
My name is Cindy Romero. I'm a wife, a mother of 5, a grandmother of 3, a part-time worker and student, and a former resident of Aurora, Colorado. I'm one of the many victims across the nation of the violent transnational gang, Trinidad, and a former lifelong Democrat.
Oh, I didn't know that.
My husband and I resided at the Edge of Lowry apartment for 4 years. And while the first few years were a pleasant experience, we soon began observing changes in our once quiet neighborhood. And in the spring and summer of 2024, we noticed shuttles dropping off large number of illegal immigrants onto the property. Throughout the year, we watched in horror as a few apartments full of migrant families quickly evolved into large groups of gun-toting, military-aged males, threatening the remaining leaseholders into abandoning their properties, then kicking in the doors to the many vacated units to make room for other gang members. Open air drug use, drug dealers, and seemingly underage prostitutes filled the common areas of the buildings.
Bruh.
Large parties in the parking lots lasted well into the morning. Stolen and abandoned vehicles blocked residents' cars. Property damage was evident. And random shootouts soon began to be expected on our block every night. These criminals brought in unlicensed electricians to run electricity to abandoned apartments and locksmiths to change the locks on the outside of the buildings to deny access to the owners, emergency services, and even the leaseholders of the building. Despite several calls for help to the Aurora Police Department, they often provided conflicting excuses for not responding. For example, one officer told me that he wanted to respond, but was instructed not to.
I believe that.
Wow.
That's crazy.
Or they were
Isn't it?
often responding to other rampant crimes across the city, or had to respond to any crime in my neighborhood with no less than 3 or 4 officers and an armored vehicle. One officer suggested I go to the media because he felt sorry for me. He likely unintentionally saved my life. Although we were low income and barely paying our bills, we realized the need to invest in home protection, and we purchased 3 additional handguns and 6 cameras in the event that we had to defend ourselves. And during June and July, the gang members slowly began to torture us through intimidation, loud arguments, physical conflicts outside our door every night, vandalizing, taking over vacant apartments on our floor. And after several confrontations with the gang members, several calls, and submitting video evidence to the Aurora Police Department with no results, we gave up trying to stop them from squatting on the property. We spent the next few weeks looking for another rental, and we were unable to locate another low-income property rental that didn't have the same exact issues that we were facing every day. We reached out to local mainstream media, several NGOs in our community, begging for help, only to be turned away because we were just ordinary taxpayers.
Yeah. Yeah, ain't that a
There were no
bitch?
government programs to grant citizens temporary protected status from imported gangs in our own country.
That's messed up, dude.
Is it that?
That is
On
messed
August
up.
18th at 11:21 p.m., 10 minutes after my now viral video was recorded, a young man who I called my friend was mortally wounded outside my apartment during a firestorm of bullets, causing thousands of dollars in damages to cars and surrounding properties by 6 gunmen later identified as Trender Agua. And thanks to the heroism of one local Aurora City Councilwoman named Danielle Durinsky and some of her friends, including John Fabricatori, they'd been sounding the alarm over TDA for months while being called a liar and ignored by their governor. I was finally able to escape these horrible conditions due to their help. In the media frenzy following the video release, many TDA members have now been identified and arrested all over the country. Danielle Durinsky has never received an apology or acknowledgement for exposing the threat. When I heard that Mr. Trump had taken an interest in Aurora and our struggles with Trender Agua, I was relieved. I was hopeful that a change was, getting ready to happen, that it was on the way, that it was impending. And as president, he did not disappoint me. And I feel safer knowing that our country becomes more secure daily. I continue to think that the lives of my family and many others in my community were put at risk by the Biden administration's failed sanctuary policies at the southern border. Sanctuary status puts citizens at risk. And we must stop pushing ideology over common sense. Thank you.
Thank you.
Yeah.
Would you show the video before we move on, please?
It's scenes coming out of a movie as the Venezuelan gang Tren de Aragua are seen breaking into apartment complexes in Aurora, Colorado. This is according to our sister station in Denver. There you can see the group well armed and forcing an apartment door open and making their way in. This has raised concerns amongst residents and Colorado state law enforcement officials.
That's crazy.
Isn't it?
Thank you. Professor.
Bruh, like in the United States of America, this should not happen here. It should not. All right. Let's see. It looks like Kate Shaw. Yeah. Okay. So
for a minute.
Yeah. Here we go.
Chairman Issa, Ranking Member Johnson, Chairman Roy, Ranking Member Scanlon, Chairman Jordan, Ranking Member Raskin, and distinguished members of the subcommittees. Thank you for the invitation to testify today. My name is Kate Shaw. I'm a professor of law at the University of Pennsylvania Carey Law School. I understand that the purpose of today's hearing is to discuss recent judicial rulings against the Trump administration and to evaluate some of the responses to those rulings being considered by this body, in particular, resolutions of impeachment against federal judges and a bill that would limit the power of district courts to issue nationwide injunctions. Let me say at the outset that in my view, the premise of this hearing, that courts have overreached or transcended the limits of their authority, and that this overreach calls for some response, is badly mistaken. It is true, as has already been noted this morning, that the Trump administration has been on a losing streak in the federal courts. A recent analysis by Professor Steve Vladeck found that of the 151 cases brought against the Trump administration since January 20th, 46 have resulted in some sort of preliminary relief. That relief has been ordered by
so less than half.
Judges across the country and by judges appointed by presidents of both parties. This broad consensus makes clear that despite the claims of some critics, these rulings do not grow out of substantive disagreements with President Trump's policy choices. The lawsuits have been brought and have overwhelmingly succeeded because many of the challenged actions have been taken
less
without
than
regard
half
for and often with outright contempt for both statutes and the Constitution.
Which she would probably be all right with it if it was Joe Biden.
Oh, of course she would. You can tell. I mean, that's the thing that, and look, we've gotten so, like, I'll say this. I would say prior to Obama, there was much less of a of a distinct divide when it came to the president, as far as like there were, for example, Republicans that greatly disagreed with Bush, again, the other one with Reagan. Plenty of Democrats who disagree with Clinton, right? And they didn't have a problem with saying so, right? They may not necessarily gravitate all the other way, but they would say, yeah, I don't. We're seeing a lot less of that these days. We're seeing Republicans that are afraid to speak up and say, you know, overall, like I do, I think Trump has been overall very positive, but there's some stuff that he's done, some stuff that he said that I've been like, yeah, no, that was wrong. Right. The red flag laws being, you know, one of those many things that
banning
exist.
the bump stock.
Yeah. Bump stock ban, stuff like that. Anyway. All right. So 138.42. We go to Representative McClintock.
Republican from California.
Look at that. Pretty close.
92% of the judges who've issued blanket injunctions against the administration have been appointed by Democrats.
Imagine that.
That at least suggests a rather partisan tilt to all this, and it's not being done even-handedly.
Right.
What's your view of that? And doesn't that undermine public confidence in our courts?
Well, I think if you look at the recent reports from various polling firms, clearly a majority of Americans believe that no single district judge should be allowed to issue a nationwide injunction.
They shouldn't.
They
I
shouldn't.
think that when you look, my judgment
Whatever
is
party it's from.
Right. Regardless of party. Now, get all of them together for, that I would at least consider. I would at least entertain the conversation. But a single district judge should not have the power to issue a nationwide injunction.
It should be a group.
Yeah. at
least,
minimum.
I don't know how many the number is,
Right.
but at least 4.
Yeah, there has to be some sort of consensus. It can't be a single individual rogue crazy. Look at the judge that just got arrested for the helping the illegals. 2 judges now.
Wisconsin and New Mexico.
I mean, that's a perfect example. You get one crazy rogue judge that's willing to break the law. How are they not going to rule against the other side? And I'm not, regardless of political leaning, that's insane.
This is clearly a judicial coup d'etat.
Yeah.
You don't have this many different judges issuing this many different nationwide injunctions, all of them coming from the same political ideological background, and just assume it's all random efforts of justice.
Come on.
This is a clear effort to stop the scale of change that President Trump represents. And I agree, a lot of this stuff can be fought out. Some of it should be fought out in Congress, but it shouldn't be micromanaging the executive branch on national security issues by random single judges who have no standing, they have no particular knowledge, they haven't been in the room, they don't know what the consequences of what they're doing are, and they put both Americans and the nation at risk when they intervene to become basically alternative presidents. You now have potentially 677 alternative presidents, none of whom won an election.
Well, we all believe in due process. Every injured party should have access to the courts, and they do. The question is whether a single district court can go beyond the case before them and apply the same decision to others whose cases are not before the court in jurisdictions that go far beyond their own. Mr. Gingrich, you've pointed out that there are several ways to address this. One is congressional action. The other is the Supreme Court putting its own house in order. In fact, the Alito dissent recently suggests that there are at least 4 of the justices who very much want to do this. It seems to me that's the cleanest and most surgical route, assuring that the rule is done from within the court and not imposed by legislation. What are your views on what the Supreme Court should do and on what you already mentioned what we should do?
Look, I think the Chief Justice would achieve far more for judicial independence if he cleaned up his own judiciary rather than lecturing the rest of us.
Good luck.
And I think there are ways he could intervene, as I mentioned in my testimony. They could establish a rule that any nationwide injunction issued by a district court will be held in abeyance and will be immediately appealed to the Supreme Court.
That's how it should be.
Lincoln makes this case. Very head-on fight, which is ironic because Chief Justice Taney, as Attorney General for Jackson, had ruled against the courts and had said as Attorney General, the courts cannot order the president. Now, he then becomes Chief Justice, extends slavery potentially to the whole country, and is lectured by Lincoln in his first inaugural as Taney sits there. And Lincoln is essentially saying, this was the law of the case, not the land, and we will not enforce it. And they don't. They never enforce Dred Scott. And so I think Chief Justice should think.
Interesting.
Isn't it?
It is very, very interesting. So it seems going all the way back to Lincoln that there has been, and before that actually, but there's always been that contention there.
And the founders wanted the 3 branches to compete.
Agree. And that's how it should be. And that's why I've said before, a lot of us seem to want quiet government, right? Just do your thing and be quiet and be nice. Nice and quiet governments are dangerous. They are dangerous because if you get all of these so-called representatives in a room and they all agree, that's a problem. It's not for your and I benefit. I can tell you that. That's why somebody like Joe Haney, LaPorte County Commissioner, you guys may watch some of these commissioner meetings and go, oh, he shouldn't have said that, or he shouldn't have did that. Yeah, he should have. He is the only voice of reason on that commission. And I personally am so glad and so thankful for the people of LaPorte County that showed up to ensure he had a second term. Because otherwise and look, with the other 2 dipshits that are on that commission, it sucks right now still, but it's better than what we would have had. Good Lord. At least he can speak.
And you were supposed to have three
This
Republicans.
hearing
on this.
reminds me of a breakfast I had with Antonin
allegedly.
Scalia. About a dozen of us congressmen invited him to breakfast, and this was about a decade ago when.
By the way, this is
Thomas Massey from
Kentucky. He's been in the news recently, like quite a bit. He actually is the only Republican that voted against. What was it? Something that just came up, and he like everybody else voted for it.
I think you're talking about
Something to do with
budget
foreign stuff.
Really?
Yeah, he said, I'll have to find it. He said he always will vote against anything that I don't remember. Well, let's just play. We'll find it.
Obama was the president and John Boehner was the speaker. And my colleagues appealed to Scalia and said, what can you do? You need to get involved here. The courts need to get involved. Obama.
The Forced Organ Harvesting Act.
Wow.
He was the only lawmaker to vote against it.
Obama's running roughshod.
That's
Need to get
interesting.
involved here. The courts need to get involved. Obama's running roughshod over Congress. And,
Do I know his quote? I got it.
Yeah.
You're right. I got it right here.
Yep.
This is his quote. He said he voted against it because it's just another example of us trying to stick our nose in another country's business and write their laws. Oh, really?
Yeah, really. I am becoming less of a fan of him as time goes on. I'm just going to say, the more, like, I was a big fan of his for a while, and the more I learn about him and the more I actually go in and dig through the votes, like this one, for example, really just mystifying.
Why would you vote against it? Because all the bill does, you want to hear it real
Yeah,
quick? Would
yeah.
authorize the Secretary of State, Marco Rubio,
Yep.
to deny U.S. passports and visitor visas to people involved in organ trafficking. Why would you vote against that?
Right, precisely. Here's the thing. He can be as against us, like he says, meddling in other countries. That's not meddling in other countries. That's preventing people from coming to the United States that are involved in organ harvesting. How can you say no to that? Sorry, homie. Big L on that one, in my opinion.
It would also call for sanctions on the entities and individuals found to have participated in it.
Yeah.
So I wonder if I've heard that he's taken it hit him hard when his wife died.
Yeah.
So I wonder if that's affecting
Could
him.
be. Could
Maybe
be.
he should retire from Congress.
Maybe. The timing of his wife's death is very, very suspicious. Very interesting.
Really?
Yeah.
We're gonna have to, I don't want to talk about it on the air.
Yeah,
but
let's not interrupt this. But yeah, we'll talk about Massey another time.
Used to accept that premise, he said, no, this is not my job to referee fights between your two branches. My job is as a jurist to decide if somebody's been harmed and what the remedy is. And occasionally we interpret the law and the constitutionality of it. He said, and by the way, you're the most powerful branch of government. I don't know what you're complaining about. All the tools you need to restore the balance are in the Constitution. And one of my colleagues protested that impeachment was just too hard to pull off, given the threshold in the Senate and the political backlash. And Scalia shook his head. He said, I'm not talking about impeachment. You'll have the power of the purse.
Mm-hmm.
You are funding everything you complain about that Obama is doing.
Yeah.
Just quit funding it.
Yeah.
And it was a pretty clear message. Now, that was about tension between Congress and the executive branch, and our hearing today is about tension between the judicial system and the executive branch. But I think it's still the case that what Scalia said is true. Let me give you an example of something I'm going to predict is going to happen in the courts soon that I'm not going to have much sympathy for on the president. So the president recently had a press conference and said he's going to wind down the Department of Education. Oh, great. That's my bill. I've got a one-sentence bill that eliminates the Department of Education. I should be very excited about this. The problem is much of the activity that he says he will undertake, he just signed into law the funding of it a week before. We did a continuing resolution that fully funds every single penny of the Department of Education. Then a week, and the president signed it.
Yeah.
This is
and we talked about that when we were talking about the Doge hearing. They literally, Rand Paul, I believe, was the one that brought it up. He was like, they're continue funding all the shit that Doge just uncovered and told us to stop. So pointless. I am sick of these so-called Republicans claiming they're there to change things.
Professor Shaw pointed out, appropriations bills are laws too, and they require both chambers and then the president to sign it. And so it's an appropriation bill, it's a law, it's in law, and a week later, he announces that he doesn't like some of the law, and so he's going to do things differently. So that's my problem. There are cases where they shouldn't have nationwide injunctions, but this is a double-edged sword. Under the Biden administration, he did unconstitutional and unlawful things during COVID that were stopped with nationwide injunctions. So, for instance, he had a rent moratorium that was stopped until the Supreme Court eventually basically said it was illegal. He refused to grant religious exemptions to the vaccines in the military. There was a nationwide injunction. Actually, one of the attorneys in that is a constituent of mine, Chris Wiest, who stopped all of the vaccine mandates at that point in the Air Force. That was a nationwide injunction. And then his OSHA vaccine mandate was stopped with the nationwide injunction. So I'm torn on this.
Right.
You know, maybe if we just don't have nationwide injunctions, people in certain districts can live under tyranny or the perception of it. And if you're in a different judicial district or circuit, you get some remedy from the tyranny. Maybe it works out better that way. Maybe we should have tried each of these cases in each of these courts and found out the answer. But
right.
That would take too long.
Yeah. Well, he makes a good point. Nationwide injunctions have been responsible in the past for reining in presidents like Biden who blatantly ignore the Constitution and just proceed with their own agenda. Should nationwide injunctions just go away? No, I don't think so. However, I don't think that a single district court judge should be able to issue a nationwide injunction. So
it should be a group.
Yeah, at minimum. Okay, so we're going to jump ahead a little bit to 154.34.
To Jamie Raskin.
Yes, indeed.
Democrat from Maryland.
34.
There we go.
And we're going to go from 154.34 to 158.45. Here we go.
Respect for the separation of powers is intertwined with respect for due process of the citizens. The gentleman from California essentially invited us to accept the deportation of someone from America without any due process at all.
Oh my God.
Which the administration.
Dude, I'm so tired of hearing this no due process bullshit. He got he got due process multiple times and was told, get out. He received a deportation order, snuck back in, got another deportation order, snuck back in, got another deportation order. Trump's just enforcing it.
And Democrats are doing this because they think it's a winning issue.
Yeah, well, that's the thing. Because look, here's the problem, guys, and I'm just as guilty. We just read the fucking headlines. We don't actually look into this stuff to see what's actually going on. We see, oh, Trump's not giving this guy due process. And then we move on. They're hoping that that's going to stick, that's what you're going to take away from that, rather than the fact that this guy's a known gang member who was been deported multiple times, snuck back in the country, then was ordered deported again. He already had his due process. Bruh.
Has admitted was a mistake because now he's hypothesizing that person belongs to a different criminal gang and engaged in other different hypothetical crimes. And obviously, the reason why we have due process is because we can't try these cases in the Judiciary Committee of the House of Representatives, but just...
I don't care. I don't care what gang he's a part of. I don't care whether he's part of a gang. I genuinely don't care because he already had a deportation order. He's not supposed to be here. It's just that simple. Gone. See ya.
Reading from a court document here, Plaintiff Abrego Garcia is not a member of, nor has any affiliation with Tren de Aragua, MS-13, or any other criminal or street gang. Although he's been accused of general gang affiliation, the U.S. government has never produced any evidence to support this unfounded accusation. He has no criminal history. He's never been charged or convicted of any criminal charges in the United States. So who knows? That's why we have due process. This shouldn't be just fodder for cable TV. We're talking about people's lives here. Professor Shaw, what does due process actually mean? And should Judge Boasberg be impeached for saying that the Alien Enemy Act of 1798 doesn't apply because we are not at war and we have not suffered an invasion by a foreign power?
We have.
The core components of due process are straightforward, right? And it involves some...
She reminds me, her voice, her cadence reminds me of someone trying to fit as much speaking as possible into as short amount of time as possible. You can tell she gives a lot of speeches. Like isn't she a professor or something?
She does a lot of lectures.
Yeah, she does. You can tell because she speaks so fast because she's trying to cram as much as possible. That's one of the first things that I learned, right? When I was running for office, I had to go and do speeches and debates and all this stuff. And you get a certain amount of time. You can't go over that time. And you want to cram as much as possible into that statement time. You got to talk faster. She's obviously picked up on that.
Notice and an opportunity to be heard, right? To make some sort of case in your own defense prior to deprivation of life, liberty, or property. So that's in the Constitution. Due process applies to every person, not just to citizens. And due process doesn't look identical if we're talking about due process in the context of potential deportation or due process in the context of, a change to your Social Security benefits, right? Due process is deeply context dependent. And all Judge Boasberg has ruled as a preliminary matter in this case is that some sort of process has to be afforded before this potentially irreversible act occurs. Judge Boasberg has not ordered anyone released in the United States, has not objected to the detention of the covered individuals, has simply said, provide reasons and an opportunity to respond. And
follow the law, right?
And follow the law. And it seems from public reporting as though there is real reason to believe that errors were made.
My colleagues are calling for the impeachment of Judge Boasberg. Has there ever been a federal district judge, a federal appeals court judge, or a U.S. Supreme Court justice impeached because someone disagrees with the content of their ruling?
We have no tradition of impeaching judges based on the contents of their rulings.
We impeach them for bribery or corruption or habitual drunkenness on the bench. Speaker Gingrich, by the way, do you agree with the Republicans and with Donald Trump and Elon Musk who are calling for the impeachment of these judges? That's a yes or no.
I actually agree with Jefferson that impeachment is a cumbersome and difficult process, virtually impossible to achieve, which is why Jefferson...
So you oppose the impeachment?
Which is why Jefferson abolished 14 courts, because you can abolish...
Okay, Professor Shaw, forgive me, you remember the 5-minute rule. I've got no more time. It's a yes or no.
What?
You should see Newt's face when he interrupted him.
Yeah.
Question, and I didn't get an answer from you.
Rude.
Chief Justice rude. I can't stand
Roberts has said that the correct response to disagreement with the district court decision is to appeal. I just heard Speaker Gingrich call this a judicial coup d'etat, and he said the Chief Justice should stop lecturing the rest of us. Who's right? Is it Newt Gingrich or is it Chief Justice Roberts here?
In this instance, Chief Justice Roberts.
Of course she's going to side with Roberts. I mean, come on. Right.
We have no tradition of impeaching judges. Appeal is the remedy for disagreeing with the district judge. Or if it's a statutory ruling that's wrong, Congress can respond, right? If it's if there's a bias or misconduct issue, there are disciplinary processes and complaints that can be brought against judges. You can seek to recuse or a remand to a different judge. There are many remedies our system affords if there is some sort of problem with the judge presiding over a case. But impeachment has never been in that toolkit.
Do you?
Okay. It's the same. It's the same crap. And it's, if you're a Republican, you agree with this. If you're a Democrat, you disagree with it, regardless of the actual issues at play here. This would have been reversed last year, a couple of years ago. We had the same thing, just in reverse. All right. So we're going to jump ahead to 159.48. Went a little too far. Come on. Why are you okay? Oh, look at that. Close enough. All right. Oh, I guess I could have just let it play. And we're going to go into Representative Fitzgerald.
Yeah, you're back, Mr.
We
Chairman.
only got a couple more.
Republican from Wisconsin.
Thank you. We now go to the gentleman from Wisconsin, Mr. Fitzgerald, and I would ask if I could have 15 seconds of his time.
I yield back to the chairman.
Okay. Mr. Speaker Gingrich, I just have one short question, and it is a yes or no, unlike the other one.
Mhm.
In your 2 decades as a member of Congress, did you see members of Congress put bills in of any sort because they were popular and felt strongly within their district, whether or not they were moving anywhere?
Of course.
And that would include things like impeachment, whether they were likely to succeed or not.
They're political symbols, not legislative symbols.
Right.
Yeah.
Very good. I thank you. I thank the gentleman
Yeah.
from Wisconsin.
Reclaiming my time. Mr. Larkin, nationwide injunctions, they're relatively new phenomenon, right? It's isn't that correct?
Yes.
Yeah, it's fair to say nationwide injunctions became more commonplace in the 60s and 70s. And that is because Congress began authorizing general rulemaking by federal agencies, such as passage of Clean Air Act or the Clean Water Act.
Well, there are several factors that led to the late development of it. One is a change in philosophy of what it meant to say that something was unconstitutional. For example, Professor Samuel Bray explained this at length in his article. Traditionally, when a court said something was unconstitutional, it meant the government could not enforce it against you. Over time, courts gradually began to say, no, that means you can't force it against anybody. The problem is that overlooks the role that a district court judge has both horizontally and vertically within the federal system. No one district court judge can bind the appellate court or the Supreme Court. No one district court judge in Maine can bind a district court judge or any judge in Alaska. And so, unfortunately, this practice developed, and we didn't have anybody stepping back and saying, no, wait a minute, are there constitutional, statutory, et cetera, limitations on it? And it has actually hurt both parties because each party has suffered through this process.
Thank you. Speaker Gingrich, as you mentioned in your testimony, between 2001 and 2023, there were 96 nationwide injunctions issued, of which 64 were granted against President Trump. Well, why do you think the courts have issued nationwide injunctions against President Trump with such frequency? It's kind of a question we're all pondering right now.
You know, one of my favorite books on the law is The Bramble Bush, which is the 1929 introductory lectures at Columbia Law School, and which draws a distinction between the law as it is practiced and the law as it is written. So let's just, at a common sense level, be honest. Donald Trump represents a profound, fundamental shaking up of a very deeply resistant establishment, which can be traced back to Franklin Roosevelt in 1933. You take on a system that's almost 100 years old, the system fights back. The last great bastion of power held by the left is district court judges and their allies on the Supreme Court. And they're behaving as a historian. This is a perfectly natural thing. They're doing everything they can to stop the president, who was elected by millions of Americans. They were elected by no one, but under our system, they have a certain amount of power. not nearly as much as the modern legal system believes, because the 1958 decision by
Right.
the Supreme Court, which said we are supreme, is baloney. Supreme Court is supreme in Article 3. It is not supreme over the whole Constitution. And I think we're now going to face a genuinely important, historic conversation as a country about whether or not unelected judges on a randomized basis, who happen to be 92% Democrat, have the power to stop the elected commander-in-chief on item after item after item. My guess is the American people will say to the legislative branch, you got to be kidding me. And if Justice Roberts wants to cut this off, he should act now, because this is going to get worse, not better.
I agree. I wholeheartedly agree. I think the majority of Americans are looking at these nationwide injunctions, especially 67, 64, 60
Something
plus
like that.
injunctions, 60 something against Trump, and going with 92% of these judges being Democrat appointed, something hokey. This is supposed to be random. I find that very difficult to believe. And I think in general, the American people should demand more. All right. So jump ahead to 210.
Jim Jordan. I think that's who that's.
Yep.
Yeah. Republican from Ohio.
All right. Here we go. Jim Jordan. This we got this one and two more, and then we're done.
Thank you, Mr. Chairman. Professor Shaw, so was Judge Boasberg correct when he said turn the plane around?
I think that protecting the jurisdiction of his
Wait,
court.
that wasn't the question. Was he correct when he said turn the plane around, bring the guys back who harassed Miss Romero, drove her out of her home, harassed her neighbors, shot her car? Was he correct when he said turn the plane around, bring those individuals back to the United States?
Based on the record before him, I think that was an absolutely defensible decision to have made in the time-pressured condition.
Miss Romero, what do you think? You agree with the professor and with the judge? Three of those individuals on the plane, Thomas Murillo Pena was wanted for kidnapping in Chile, was in the Denver area where they got him. Javier Vargas Lugo, attempted kidnapping, was in the Denver area. Nixon Azusa Perez was in the Aurora area. He may have been one of the guys who harassed you. Do you think that plane should have came back and brought those individuals back to the United States?
I feel safer every time a plane is loaded up and leaving this country.
Thank you.
The previous member.
That was a great answer.
From California talked about your riveting testimony. One of the lines you had in your testimony that got everyone's attention was, quote, there are no government programs to grant citizens temporary protected status from imported gangs in our country. Amen to that. There is none. And that's why this is so important that we move these people out. Mr. Speaker, should the judge who's been assigned the Hegseth case, Judge Boasberg, should he recuse himself from that case? And understand the standard. I know you do, Speaker. The standard is a reasonable person. Would a reasonable person believe that this judge can't be impartial with this case? And I would just remind you of a couple things. This is the judge who was on the FISA court when they granted warrants to spy on President Trump's campaign. This is the judge who handled the Kevin Kleinsmith case, an FBI lawyer who lied to the FISA court to help get those warrants and was given a slap on the wrist by Judge Boasberg. Not my words, the Wall Street Journal said it, because it was. He was a member of the bar, lied to a court, and got some probationary sentence.
It's bullshit.
So now this judge said, turn the plane around, and now he's been assigned the Hegseth case. And I'm just asking, do you think Judge Boasberg should recuse himself from that case?
Yes.
I think this is a classic case where the Chief Justice should intervene. I mean, when you have blatant, continuing record of prejudice, that judge should not be put in charge of a case.
Right.
And as I said earlier, I'm not for going through the whole process of impeachment, because I think it's at a practical level not possible. I am, however, for using the potential capacity of the Congress to simply defund, which Jefferson did, and which clearly is possible. But I think what you just described is illustrative of why I use the term coup d'etat. You have a small group of people who believe that they have the right to arrogate rejecting the American people and doing whatever they want and cooperating with people who clearly were behaving illegally. I mean, that's one of the great tragedies of the last 6 or 8 years is
Right.
it's the government which has been illegal.
Mhm.
It's the FBI which was illegal.
Mhm.
And how can you possibly have the rule of law when the people in charge of the law are illegal? I think in that case, you raise a very powerful point.
Mr. Larkin, should Judge Boasberg recuse himself in the Hegseth case?
Oh, I don't want to offer an opinion about a specific case that I'm.
I don't blame you. I
Good
don't blame you.
answer.
All right. So we're going to jump ahead to Representative Cohen.
Democrat from Tennessee.
Okay, and we're going to 218.33, 215.58 to 218.33. So about 3.5 minutes. And then we got one more for you, and that's it.
The judicial branch in our country plays a critical role in checks and balances, which is the Constitution mandates. Our president doesn't understand that or respect it. And in my opinion, he accordingly is the one doing the overreach, not the judiciary. He overreaches with birthright citizenship, which is in the Constitution, and he can't, with an executive order, a press release with a nice stationery and a little sign on it, overrule the Constitution. Nor can he declare a third party, a third term for himself, which.
All right. Why he did that, he wanted to create a controversy so that the courts would look at it.
Yeah, would actually look and rule on it.
Because they've never ruled on it.
They refuse to touch it. They refuse to
And they're
touch
going
it.
to now.
Oh, yeah.
And
yeah.
Trump is not going to run for a third term. I knew he wasn't going.
He
even
won't
said
run,
that.
but I think he enjoys watching them go nuts
He
about.
even admitted it a couple of days ago that he wasn't
he's
going.
like, I'm not doing that. I got no interest in that. I don't blame him, dude. The fact that he ran and won a second time, like, more power to him, because I don't know. Excuse me. I don't think I'd have done it.
No.
Like, dude, all the sheer just bull he has to deal with.
He'll probably do eventually, that he can run for office again.
I don't
He
know.
can't do
Not
that.
going to run again.
If I had billions of dollars, though, I might, because you don't. What do you need at that point? You're set. You're good.
True.
I mean, watching the heads explode is vastly entertaining. So
he enjoys that. I
he
bet.
does. Oh, he gets off.
This man is abusing the office of the president by signing executive orders in so many areas against the Congress for passing appropriations bill, which he doesn't respect, and by destroying agencies created by the Congress, which he can't do because they're independent, like the Peace Institute. It's an independent, but he's gone in and taken it over.
So if he can't do it, then how'd he do it? He can't do it, but he did it. Really?
He's also gone
This
after
guy's an
lawyers and law firms. And it's no mystery why he did it. Jenner and Block and Wilmer Hale, they are two firms that have had attorneys with them. Andrew Wiseman, who worked at Jenner and Block, and Robert Mueller, who worked at Wilmer Hale, who had cases against the president. To get into court, you've got to have an attorney. And if attorneys are fearful of having their opportunities to interact with the federal government, to enter federal buildings, to have clearances, they will be reluctant to take cases. That destroys the opportunity for the Justice Department, for the Judiciary, for the third branch to work as a check and balance. You destroy it when you don't have somebody to give you entree into the courts. Professor Shaw, your testimony was brilliant. Just to ask you about a federal judge. Federal judge cannot institute a case, can they?
No, sir, they cannot.
So what they do is they
Nobody's
take what
saying that.
lawyers
Right.
put before them, and then they determine what it is.
A case or controversy is brought to a federal court, and a federal court can resolve it. They're not a self-starting body.
But if lawyers are afraid to bring an action against the administration or the president, then the courts won't ever get a chance to do anything.
Absolutely. And I think it is important to understand some of the attacks on lawyers and law firms as indirectly attacks on the judiciary, as well as attacks on the ability of what causes the president may deem unpopular to secure representation or for litigation against the federal government to proceed. So I think that all of those values are implicated in the attacks on lawyers and law firms.
Do you remember?
And I just want to point out that the Democrats were perfectly okay with the Biden administration going after reporters, Obama going after Fox News. They were all okay with that. So let these clowns have their circus. We're in the paint and the stilt men, because that's all it is. It's performative art at this point. They do not have the votes in the House to stop anything Republicans want to do. So cry some more. Shit. All right. We're going to jump to our last clip, which is 222:01. If I can find it. Close.
It's the woman from Wyoming who beat Liz Cheney.
Oh, nice. Okay. All right. I'm back a little bit. And this is our last clip. We're going to go to 227:41.
So about 5 minutes.
About 5 minutes. And then once we wrap that up, we're going to talk about the Constitution and what it actually says.
Hagerman.
The only. In March, the Miami Herald reported on a team of former U.S. officials and Venezuelans assisting the Trump administration with tracking Tendrigua, or TDA. They have focused on ties between TDA and the Maduro regime, identifying 1,800 gang members sent to our country. Reportedly, 300 received paramilitary training in Venezuela, and the regime has operational control over them. Information obtained by the team from police agencies in South America has resulted in the arrest of at least 800 TDA members or smaller affiliated entities. According to the article, TDA has been setting up a drug distribution system in our country, and the individuals, quote, are not criminals sent to cause havoc. They are soldiers sent in an asymmetrical warfare operation against the United States, end quote. On March 15th, President Trump issued an EO invoking the Alien Enemies Act regarding the TDA invasion. The EO finds that TDA is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. TDA is undertaking hostile actions and conducting irregular warfare against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. Judge Boasberg of the D.C. District Court recently ordered the Trump administration to turn around removal flights bound for El Salvador carrying members of this Venezuelan terrorist group, TDA. Judge Boasberg's temporary restraining order at first was limited to the named plaintiffs, but he later provisionally certified a class for, quote, all non-citizens in U.S. custody who are subject to President Trump's order against TDA and its implementation. Mr. Larkin, what are the problems associated with the breadth of this order rather than it having being just applied solely to the parties in front of it?
There seem to be at least two issues. One is whether I'm told, I haven't seen the complaint, but I'm told that the complaint that was filed seeking relief was brought under the Administrative Procedure Act. That's not an appropriate vehicle for this. It should be the federal habeas corpus laws. But secondly, if you're going to grant class-wide relief, you have to first properly certify a class. The Supreme Court has so ruled and has told the district courts that they have to do first the job of certifying the class and only then awarding class relief. In footnote 1 in Baxter versus, I think it's pronounced Palmigiano, but don't hold me to that. The Supreme Court said the district court had gotten it wrong in that case for following the reverse order. So if that's what happened, what happens then is there are steps that you have to go through in order to certify a class. And to my knowledge, although, like I said, I haven't followed that case, I don't know if those steps were followed here. My understanding is
it looked like it jumped.
Did
you see that?
That was really weird.
That was weird. This is, I mean, it's Forbes, but I don't know.
Is that
what
this is the first I've heard of it from you. So
Well, and there's another problem associated with that as well. In the case involving TDA, the judges and other injunctions that have been issued, nationwide injunctions issued by these courts, they have not been requiring the party seeking the injunction to put up a bond, even though Rule 65 of the Federal Rules of Civil Procedure mandates that a party seeking a preliminary injunction or TRO must provide security, a bond to cover potential costs and damages to the party who is wrongfully restrained or enjoined. In fact, such a bond is a condition precedent for an injunction to be valid. So in light of that, does this violation or failure to require the posting of a bond undermine, if not actually nullify, the legality of Judge Boasberg's order?
I have to say, and it's going to sound like begging off, but I'm not trying to, that I haven't researched that effect in this sort of context, in part because I'm not sure how you set a bond in a case like this, where what you're talking about is essentially relief that should be granted under the habeas corpus laws. And so to the extent there are separate procedures that you have to follow in a habeas corpus action, I don't know to what extent that part of Rule 65 would apply.
So what I'd like to do is I would encourage you to read the opinion article in the Wall Street Journal from yesterday entitled "Why Judge Boasberg's Deportation Order is Legally Invalid." And this individual, Daniel Huff, goes through the analysis of what is required under Rule 65 for an injunction to be enforceable. Yeah. And one of the problems associated.
Have you read that?
I have not.
With the decision is the fact that no bonds have been required in these injunctions.
And not every provision in the Federal Rules of Civil Procedure automatically translates over to habeas corpus. And I just don't know if that provision does. If it does, then it has to be addressed. If it doesn't, then you have a different set of rules that you follow.
Would the gentlelady yield for 1 second?
Sure.
Would your question,
Mr. Chairman,
thank you. Would your question be for all of these cases, not just the one that you were speaking of?
That is correct, for all of the injunctions that have been issued in these decisions around the country. And I also.
It's a fair point.
Uh-huh.
I mean, that's just the way it is. All right, so let's look at the Constitution here. Okay, so this is constitutioncenter.org. It's just where I could find it at. And this is Article 3 of the Constitution of the United States of America. It says here, Section 1, the judicial power of the United States shall be vested in one Supreme Court. And notice it's lowercase. I think that's important to remember.
Oh, yeah.
A lot of people think the Supreme Court is capitalized, at least in the formation of the Constitution. It was lowercase because it wasn't its title. It was just saying, this is the court, overall courts, not overall people, overall courts. It says, and in such inferior courts as the Congress may from time to time ordain and establish. Congress ordain and establish any inferior courts. The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished during their continuance in office. And then it goes into interpretations. Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority. And then it talks about to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states. This was changed by the 11th Amendment. To controversies between two or more states, between a state and citizens of another state, citizens of a different states, et cetera, et cetera. As it says here, it was a portion that was changed by the 11th Amendment. Do you know offhand the 11th Amendment, Shawn?
I don't.
11th.
You don't hear about the 11th Amendment often.
Limits the judicial power of the federal courts. That's interesting. Specifically, it prohibits suits against a state by citizens of another state or foreign citizens. This amendment effectively grants states sovereign immunity from such lawsuits in federal court. Ratified in 1798, et cetera, et cetera. In that case, the court had ruled that states could be sued in federal court by citizens of other states. This amendment reversed that decision. In all cases affecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction. That means upon appeal, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. Now, I think that's very interesting that Congress is given the power to regulate the courts. The trial of all crimes, except in cases of impeachment, shall be by jury. Now, this is very, very, very important, guys. I don't know if you know this, but there are many, many, many jurisdictions around the country where they have taken away your right to trial by jury.
Wow.
Yeah. The trial of all crimes except impeachment shall be by jury, period. And such trials shall be held in the state where the said crime shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. Section 3, it talks about treason. No, this is interesting though. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. Now that is interesting because what do we consider a witness these days? Is videotape evidence a witness?
That is true.
Is a cell phone recording of a voice, is that a witness?
That's true. The founders never knew.
Right. You didn't think about this kind of technology. So it would be interesting to find that out. I'm not going to dig into that right now. We're going to wrap this up. It says there's a Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. What the hell does that mean? It means the sins of the father shall not carry on to the son. It's talking about corruption of blood or forfeiture. In other words, they can't pass it on to your kin. You might have been a traitor, but it's just you. And that's it, guys. That's what the Constitution says about this. I find that very interesting and very succinct. There is not a lot of crap in there about injunctions or other federal courts or any of that. It's interesting, at least to me. What do you guys think? Let us know in the comments. Tell us what you think about this. Do you think that they are overreaching with these injunctions? Do you think that these injunctions should happen at all? Or should they happen, but maybe not a single randomly picked judge should be able to issue it?
Shouldn't be.
Yeah. I think it's something that we can all talk about and learn from because, look, guys, civics is hard. There's a lot. And we used to have the classes in school that would teach us how our government actually works. And they've gotten away from that. I mean, you're lucky if you know about the 3 branches at this point.
Or most of the people that are on the Supreme Court.
Right. Most, dude. So I saw a video the other day, and it was a guy going around asking high school graduates basic ass questions. Like the Civil War, who fought it? The answers were heartbreaking. And these people weren't kidding. They weren't like, it was Britain and France. No, they were serious. They were dead ass serious. And it was embarrassing. I was like, no way, dude. No way. This is America. Yeah. And we used to be one of the most highly educated nations in the country or in the world. One of the best. America, remember the term American exceptionalism? When's the last time you heard that actually applied these days? What do we excel at now? Other than whining on the internet. We're good about that.
What about that?
I mean, yeah. Obesity, debt. Speaking of obesity, I just want to touch on this really briefly before we go. A lot of people are giving RFK Jr. a hard time about the changes that he wants to make, the NIH director, right? HHS, thank you. Yeah. Which oversees NIH. But like, people are like, don't take away my Cheetos, stuff like that. I am here to tell you, I have personal experience with this. We were actually talking about it earlier. My son does not do well with artificial colors. Let's just say that. He does not do well at all. We told Shawn a little bit about that. And I'm not saying that you shouldn't be able to go out and gorge your face with artificial colors if that's what you want. But when the option exists to use other things, we should encourage these companies to use other things. Other countries do not have half of the crap that we allow in our foods. That's just the way that it is. We can argue about, whether their healthcare system is better than ours or worse than ours or any of that. But ultimately, I think we're going to come out okay from that. I hope. Fingers crossed. RFK, I think he's on the right path. I think he could use more support from everyday Americans. It's very easy to get wrapped up in this. Watch the news. And I'm not talking about a particular side. Both sides of this so-called red and blue coin, they're the same, man. They really are. At the end of the day, it's one wing of the same buzzard that gonna
Liz
eat
and
us.
I were just talking about that.
Yep. All right, guys. That's it for tonight. I think this stream's long enough, and we'll talk to you again soon. As a matter of fact, tomorrow night we have a great one coming up for you, and I hope you'll join us. See you again real soon. God bless you. God bless Indiana, and God bless the United States of America. I hope you have a wonderful evening. Mwah! Good night.